I'm Jeff Rivard. I'm one of the attorneys at Topeka, Daly, Pope & Perry, and I'd like to talk to you about probate and the role it plays after someone dies. Probate is a court-supervised legal process that occurs after someone dies that has a number of different steps in it. First, you need to figure out all the assets a decedent owned and how they're titled, and then you also need to determine if the decedent had a will and what it says about who the decedent wanted to be responsible for taking care of affairs. Then, the process proceeds a little differently depending on the situation. First, we need to quickly define a probate asset as a solely owned asset that has no other means of being passed on to a successor owner. A probate asset cannot go to where the decedent wanted it to go until the probate process is fully completed and the probate court authorizes the asset to be distributed to the proper beneficiary. In Connecticut, the probate process can proceed in one of three different ways. Sometimes there needs to be a full estate. If there's any solely owned real estate or probate assets that are valued in excess of $40,000, then a full estate is needed. If there's a will, it gets formally admitted to the probate court, and an executor is named to be legally responsible for taking care of affairs. Sometimes, if there is no will, the probate court can still name someone, only then in that case they're known as the administrator. Second possibility, we may only need a small estate. If there is no solely owned real estate and less than $40,000 worth of probate assets, then even if there's a will, it doesn't need to get formally admitted and no executor is named. Instead, things could get taken care of much more simply by filing a much simpler affidavit document. Third possibility, if there's no probate assets whatsoever, then it may be that only an estate tax return is needed, which is what the probate court refers to as a tax purposes only filing. Now, if the executor administrator is appointed, what are they responsible for? Well, there's a lot of things. They need to report to the probate court all the assets and their values. They need to sort out and satisfy claims. They need to administer assets, physically safeguarding some things, making investment decisions, deciding whether to sell an asset or not. And they also need to file an estate tax return and pay a probate fee. And then at the end of the process, they need to give an accounting to the probate court of everything they did and to officially seek permission to be able to distribute all the remaining assets to the beneficiaries. Now, there are a couple of big downsides to the probate process. One is a question of liquidity. Probate courts operate very slowly, and it may take a while to get the executor appointed. Meanwhile, bills and expenses may keep piling up without any cash to pay them. But a bigger concern is one of privacy. Pretty much everything a probate court does is part of the public record. So as soon as a will is filed, it becomes accessible to prying eyes. So what can be done? Well, there's a number of forms of ownership for an asset that mean that they don't have to go through the probate process at all. A jointly owned asset, an asset that's going to pass on by beneficiary designation, or a transfer on death provision, or any asset that's held in trust. In fact, setting up and funding a revocable living trust can be an excellent way to avoid the probate process altogether. If you have any questions, go ahead and give us a call at the office. Thank you.